Good evening, and on behalf of Venable, I want to welcome you all here this evening. My name is Brian Schwab. I'm a partner here in our DC headquarters in our commercial litigation group, and as of about 6 weeks ago, the new vice chairman of our firm, and I'm very, very pleased that we're able to host this evening's panel discussion. For the past many years, I've been Venable's representative to the board for the Council for Court Excellence. And as somebody who practices in the D.C. courts and lives here in our city, I'm constantly amazed at how the council is doing important, thought-provoking work that has a real impact on those of us who live and practice and work in the city. And tonight's panel is certainly consistent with that track record, a fascinating topic, an all-star panelist, group of panelists. So with that, I want to introduce Laura Hanman, who really put this entire evening together to start us off. And thank you again for being here.
This is the first program in 2012 of CCE's continuing bench bar media examination. Eric Lieberman, General Counsel of the Washington Post, a newspaper, and I co-chair this initiative. We began in 2007, and in 2009 we published the DC Journalist Handbook to the DC courts. You see it outside on the table out there. And following the publication, we got along so well with everyone who was working on the handbook, including the judges, that we decided it was time to have a dialogues project. So we've had 4 dialogues so far in 2011. A panel discussion with the participants in the Scooter Libby prosecution about the media aspects of the trial. A discussion of the issues around confidentiality in the juvenile justice system. A conversation, informal conversation for the bench bar and media, a somewhat venting session and also sharing perspectives. And then we ended last season with a Fred-friendly panel on social networks, technology, and the courts. Tonight, I want to also thank, in organizing tonight's program, Lucy Dalglish, who will be moderating tonight's program, Jerry Ann Timmerman, and Chuck Tobin for all their help. And, of course, CCE's incomparable Pete Wilner in the back there, who makes these events happen. I also want to thank Shelley Snook, Leah Gerwitz, and Barbara Wall for helping to recruit some of our stellar panel here. And the committee as a whole is planning 3 more projects, and busy at work are Henri Covin, Barry Coburn, Andy Glass, Lee Levine, Ashley Messenger, Jack Murphy, Jennifer O'Connor, Justin Schur, Arabella Teal, Steve Vermeil, and Kurt Wimmer, and I thank them all very much for their help. So tonight it's my privilege to introduce our panel, and their bios are attached to our materials. As you know, starting at 2 p.m. yesterday and 2 p.m. today, we were able to listen but not see the argument in the Supreme Court on the health care law. And also in July of 2001, began the experiment in civil trials in federal district courts, select districts around the country, and that experiment is ongoing. So our discussion tonight is extremely timely. It is also on the record. Lucy Dalglish, tonight's moderator, is the executive director of the Reporters Committee for Freedom of the Press, which has been representing reporters and news organizations for the past 40 years. Lucy herself is a lawyer and a past reporter, and 3 weeks ago I had the privilege of witnessing Lucy receive the 2011 W.M. Kiplinger Award for Distinguished Contributions to Journalism, presented by the National Press Foundation. And apropos of tonight's discussion, Lucy signed the letter on behalf of 46 media organizations and companies requesting camera coverage of the healthcare arguments in the Supreme Court this week. On our panel is, of course, Chief Judge Royce Lamberth of the U.S. District Court for D.C. He has had numerous important roles and including serving on the most secret of all courts, the Foreign Intelligence Surveillance Court. No cameras there. No parties there. The Chief Judge is a current member of the Judicial Conference of the United States, which is, of course, deciding the fate of cameras in the federal courts. And we thank Judge Lamberth so much for his strong support for our Journalist Handbook and for the Dialogue Project. We are also honored to have Judge Lopez, who is on the D.C. Superior Court. He has served in the civil, criminal, and family divisions of the court and is currently presiding judge of the Domestic Violence Unit. He is past chair of the Superior Court's Judicial Education Committee and recently traveled to Mexico and Chile to look at their judicial systems. Kathleen Kirby, at the end there, is a partner at the law firm of Wiley, Rein, co-chair of the firm's media group, and general counsel to the Radio Television Digital News Association. She is regularly rated by Chambers USA as one of D.C.'s leading lawyers in her field and is one of the super lawyers in D.C. Machen is the United States Attorney for the District of Columbia. Before becoming U.S. Attorney, Mr. Machen was a partner at WilmerHale. In 2008, he was named one of the 50 most influential minority lawyers in America by the National Law Journal. Michael Satin is filling in for the ailing Avis Buchanan. He is the training director of the D.C. Public Defender Service. The Public Defender Service received the Frederick Douglass Human Rights Award in 2010 and is recognized as one of the finest public defender offices in the country. Mr. Satin has tried dozens of cases before juries, including for the most serious offenses. He is an adjunct professor at Cornell Law School and American University Washington College of Law, and he is also a faculty member at Harvard Law School's Trial Advocacy Workshop. Finally, we have Fred D'Ambrosi, who is the news director for WUSA-9 TV. He has won numerous awards for journalism, including several Emmys. He has covered many notorious trials, including the trial of Jeffrey Dahmer, the infamous Milwaukee cannibal, which he tells me had cameras in the court for all the grisly goings-on. So thank you, panel. And Lucy, would you...
Thank you, Laura. Now I understand what it must feel like to be a member of the clergy. There are chairs up here. If anyone would like to fill in. Well, as Laura pointed out to you, I have a perspective on this issue, and hopefully I'm going to be able to tamp it down a little bit. But this is something that the Reporters Committee has been working on for many, many years. Just to give you a little bit of background about cameras in the courts here and elsewhere in the United States. All 50 states have declared themselves willing to open up some court business to cameras, although the levels of that openness really vary from state to state. In fact, in the last 18 months, Pennsylvania, Minnesota, South Dakota, and Illinois have amended court procedures to be even more court-friendly and camera-friendly. The Pennsylvania Supreme Court and South Dakota trial courts are now permanently opened to cameras, while Illinois and Minnesota are allowing cameras in trial courts as a pilot project. In all but one state, photographing jurors is not allowed, and in many states it is routine to not allow camera coverage of victims of violent crimes. The highest courts in 37 states provide webcasts, video, or audio recordings of their oral arguments online. Now, in the 1970s and 1980s, Wisconsin and Florida led the way and began to routinely allow still and television photography in criminal courtrooms. Televised court proceedings first reached a mass audience in 1991 with the creation of Court TV, which is now called In Session, and the trial of serial killer Jeffrey Dahmer in Milwaukee. While the Dahmer trial was conducted with few, if any, complications, other high-profile cases, most notably the O.J. Simpson murder trial, caused concerns that justice was being reduced to entertainment. Opponents still cite that case as an example of how the presence of cameras can lead a jury to consider public opinion rather than testimony. They also voice concerns that cameras can cause a chilling effect on witnesses and victims. Now, while some states have allowed cameras in courtrooms for decades, that has not been the experience in federal courtrooms. But there has been some movement toward cameras in federal courtrooms in recent years. The Judicial Conference of the United States has authorized a 3-year pilot project allowing cameras in civil cases in 14 federal districts' courts. None of those 14 jurisdictions are anywhere near D.C., Maryland, or Virginia. Legislation has been proposed to force the United States Supreme Court to open up to cameras. And while Senators Grassley and former Senator Specter and a handful of others feel strongly that cameras should be allowed into the Supreme Court, the court as it is currently comprised is unlikely to allow it. The latest example of the Supreme Court's attitude toward cameras is occurring this week, as you know. C-SPAN and a coalition of media organizations led by the Reporters Committee asked the court to allow some form of video recording of this week's healthcare law challenge. But the court rejected those requests, but has been releasing audio recordings within a couple of hours of the conclusion of the arguments. Like several of you in the audience, I have been working on these general issues since the mid-1980s. The Center for Court Excellence Committee that worked on this program looked at dozens of potential cameras in court subtopics before deciding to focus on 2 broad areas for tonight's discussion. We will be focused primarily on technology, and because this week the U.S. Supreme Court is considering one of the most important cases in decades, we will be discussing access to U.S. Supreme Court arguments. But we'll obviously be asking some basic questions about the pros and cons of camera coverage in general as we go along. We'll be talking for probably the next 25 to 30 minutes, and then we will be opening the discussion to questions from the audience. So let's get started. First of all, I'd like to ask our panelists, have any of you either participated as a participant in a televised trial or covered one as a journalist? Any?
Well, I mean,
Yeah.
counting as news director, I
Sure.
wasn't actually in the courtroom, but I've coordinated many big trials, especially Dahmer, with 0 problems. I came here, my previous 20 years in the business were in Wisconsin and in California. So I just had forgotten that there were places that didn't put cameras in the courtroom, and came here. I thought at least one of the jurisdictions would have it, having just gone through the Hughley trial, which was big, which even had a closed circuit camera. But so there was in fact a camera in the courtroom in the Hughley trial, but we couldn't use it. You could sit in another room, you could watch, you could take notes, but you couldn't use it. So yeah, I've had many experiences. The David Westerfield trial in San Diego, which was huge and was televised nationally, was a murder case. And again, my experiences with planning and with discussion with the judge, and we always start out with that, meeting with the judge prior to planning out everything. Where can we have a camera? Where can people watch closed circuit feed of the trial to prevent, huge lines and problems in the courtroom? And then where can we do what we always refer to as post-game, when the attorneys come out, if they choose to say something or any of the witnesses choose to say something, where can we meet with them that's not going to be disruptive? And because of that planning, there was never a problem. Here, I feel like because there isn't cameras in the courtroom, there's no planning of anything. And every big trial I've gone to, including Hughley, I mean, it's a mess. I mean, it just turns into Lord of the Flies out in front of the courthouse. I don't think that benefits anyone. I think there needs to be more planning, and it starts with cameras in the courtroom and it proceeds to a thought of, this trial is going to get covered one way or another. Can we please talk about it and plan and do it intelligently? And I don't believe it doesn't happen here.
Anyone else? It's just, and just a show of hands, anyone in the audience, I'm not going to ask you to confess and go into great detail, but has anyone else ever participated as a participant in what state?
Florida.
Florida. Chuck, Florida? All right. Okay, that's helpful. Thanks. Now, those of us who went to journalism school and law school in the dark ages learned about the 1965 conviction of Billy Saul Estes in Texas that was overturned in part because of the circus-like coverage and atmosphere in the courtroom. That was the first and last conviction in this country to be overturned in part because of camera coverage. I've seen photos of the inside of the courtroom during that trial, and it's clear that there were heavy cables threaded throughout the courtroom. Microphones were in everyone's face, and the cameras back then, of course, were absolutely enormous on these huge wheels, and, you know, they were kind of a nightmare. But these days, it's possible to record camera or courtroom activity with one of these. So it's pretty small and unobtrusive, so we must be talking about something else that raises the perils of camera coverage today. So I'd like to get, perhaps with Judge Lopez and Judge Lamberth, can you tell us what some of those concerns might be? Or maybe the concern actually still is technology.
I don't think technology is the issue any longer because, as you say, those issues have been largely solved, and we're seeing in the first year of our experiment in the federal courts now that are trying this in civil cases that we're running the technology ourselves. We're doing it with our equipment, so we know exactly what we're doing, and we're finding unobtrusive ways to do it. So that I think technology is not the issue. The issue more is certainly in the criminal area, whether it will affect witness testimony, victim testimony, and have an impact on how witnesses perceive their testimony, and obviously some concern about jurors, although there's less concern about jurors since we know that in the federal courts where we're doing the experimenting, we're not allowing any coverage of jurors at all. So we know, since we're running the cameras, we know we can control that. I think that this federal experiment will give us some data that in 3 years we can make some more reasonable judgments about. And the technology area is certainly one of those areas that a lot of this will wash away. How you then implement whatever we're going to do in the federal courts remains to be seen, and obviously criminal is the most difficult area to implement. Civil will be some problems. Appellate, I'm probably ready to throw in the towel now and say I don't really understand any reason why appellate cases couldn't be televised. The Ninth Circuit does it now. The D.C. Circuit could, but won't because we have the current policy of only doing it in those experimental places where we're doing it. But I don't really think there's a lot of opposition even in the D.C. Circuit to allowing appellate arguments to be televised. The Supreme Court is another whole category. I mean, that will be, there will have to be some deaths before it happens there, I would say.
Yeah.
Could be resignations rather than death, I agree.
Our sense is similar to the sense that Judge Lamberth just voiced regarding the concerns. Back in 2003, we had a committee of judges that were working on an experiment to have cameras in court, and they even came to the point of developing a proposed rule with certain restrictions and concerns. But when you look at the rule, those are the restrictions and concerns that come about. Concern about the witnesses, concern about the defendant, reluctance jurors, and so forth. We function as a board of judges, so it gets more complicated in order to get a decision made about such thing. Back in 2003, we had a good division of judges going one way and the other. Since that time, the issue has never been brought up. This is the first time that it gets brought up again. So we're ready for dialogue.
Ron, Machen, does the Justice Department have any standard policy on this, or is it something that you haven't had to do because it's not an issue?
Well, most U.S. attorneys don't have to deal with it because there's a federal rule that prohibits cameras in the courtroom. My jurisdiction, I'm unique because we represent the local jurisdiction and the federal, but Superior Court, as Judge Lopez says, doesn't allow the cameras. I think the thing that would concern me about cameras in the courtroom is the same thing, the chilling effect that it would have on witnesses. And that's a real effect. And it's hard for somebody sometimes in the media to understand it. But in D.C., so much of what we do is focused on violent crime. In the last 2 months, we've had 3 cases involving government witnesses who were murdered. One of those cases, we're waiting for a verdict right now. And I can't tell you how real the threat is to witnesses, and how the potential to have a newsreel or sometimes on these websites to have just an ongoing access to somebody testifying, how that would have an even further chilling effect on getting witnesses to cooperate and report the truth about what they saw. If there was a way to get around that, that would be something we could deal with. But I'm telling you, it is a real concern for prosecutors in our jurisdiction.
So if there was a possibility to file a motion and say, okay, we would like these 4 witnesses to not testify on camera, would that take care of the problem? Or not?
I mean, it could take care of the problem, but I'm telling you, it would be so cumbersome. There will be a lot of motions because a lot of the witnesses, even the witnesses that may not necessarily be cooperators, are not going to want to testify. And so I don't know what would be left, quite frankly, because you have a lot of witnesses who see their loved ones get killed, who will not testify, do not want to testify because of the stigma of being labeled a snitch and because of the real life danger of that. And one of the cases I'm talking about, a guy testified for the government in 1995, and he was murdered 12 years later for what he did in 1995. So there's a real concern there, and I think that's what our number one concern is, always witness safety, and I think we'd have to figure out a way to get around that. But I think it's more complicated than just filing a motion to exclude these 3 or 4 witnesses.
Ooh. Michael, do you have any thoughts on protecting victims, witnesses, defendants? I mean, would the public defender's office have a position on cameras in courtrooms?
It's possible they do, but Avis is sick, so I'm not sure I'm aware of it if we do. But I can tell you my own, I guess, personal views, and hopefully they'll be consistent with what Avis would say if she were here, which is I think there's a distinction to be made between what's cameras in the courtroom at the trial level and that of the appellate level, because there is, at the appellate level, and obviously the interest that people have in watching the Supreme Court cases, other appellate arguments, policy is being made, law is being made that affect society. At the trial level, it strikes me as being voyeuristic. There's very little to be gained from what happens at the expense of what to me is the paramount interest, and that is the fairness of the defendant in the trial. And that's what trumps the other considerations in my view. And I think that the constitutional law as well as sort of policy interests sort of support that, the notion that what is most important in a criminal trial is the right of the defendant. And that is likely to be compromised if there are cameras in the courtroom. In part, it even could be to the windfall of the defense if there are witnesses who are afraid to come forward, although that works the other way as well, because there would be witnesses that we would want to call that might also have some hesitation about coming forward. But you also have this issue of jurors or potential jurors being tainted by exposure in the media, things that are being said. Even cases I've tried where there isn't TV coverage, but there's media coverage, whether it's at an arraignment, other types of hearings, we are essentially, I mean both litigants, the prosecutors and the defense, are making arguments knowing how it might be perceived by potential jurors in the future. Witnesses who are on the witness stand, a big part of the evaluation of their testimony is going to be based on their demeanor and behavior on the stand, but it could be undermined by how they might worry about how they're going to look on TV. So these various issues might ultimately affect the fairness to the defense, or fairness really to both sides, particularly the defense, of their trial, and at what benefit to whom. And really to me, and I think a lot of the high publicity cases, Casey Anthony in Florida, other types of trials, they don't actually increase the public's awareness or knowledge of the legal system. It could either lower it, quite frankly, and certainly it just feeds into this voyeuristic or entertainment notion or benefit to be derived from watching the trials.
Okay, Kathy, Kirby, you deal with
That may be the only time I agree with PDS on that. Very noteworthy moment.
Well, I guess I forgot my big point, though, is that perhaps maybe if the government's worried about safety of the witness, they should just not bring the case at all.
Kathy, you deal with more jurisdictions and more televised trials than anybody in America. And I know you're involved in virtually all of them in some way. These concerns that have been raised, how do most locations, most states that allow cameras, how do they deal with them?
Well, I think you have to draw on the rich experience of the states, many of which allow cameras in criminal trials. I just was speaking with an RTDNA member about coverage of the John Goodman trial down in Palm Beach County. This billionaire struck a teenager, or a young man actually, in his 20s with his car and left him to drown in a ditch, essentially. And there was public outcry, public outrage. But this clearly was going to be a high-profile trial. So in states with considerable experience with cameras, they put a media plan in place prior to the trial. The judge has a good deal of discretion on how to manage juror issues, witness issues, technology issues in the courtroom. In this case, the former Court TV actually had several robotic cameras inside the courtroom. They were prohibited from showing jurors. They used delay technology. There was no exclusion on showing witnesses. There didn't seem to be any ill effect on the defendant's right to a fair trial in this case. I'm sure his attorney, Roy Black, will appeal. But I think the bottom line is that it really isn't just voyeuristic. If you think about the right to a public trial, it was put in place for the purpose of the defendant getting a fair shake and accountability of our judicial system, and it's working in the states. And the media, and in a lot of cases there are media judiciary committees who are working very well together to arrive at that kind of transparency and accountability. And the more experience they have with cameras, the more favorable actually the judges are to it.
Before we slightly adjust, Fred, these concerns that you're hearing about witnesses won't want to testify, they'll be fearful and everything. How would you, if you were allowed to use cameras, is there anything you would do to account for those situations?
Well, I mean, again, I go back to 30 years of cameras in the courtroom in states where I've worked, Wisconsin and California. We handled different problems differently. The judge always addressed them. So, for example, a juvenile testifying, the judge said, you can't show her, you can't record her. We didn't. I'm not aware of any incidents where someone didn't testify because there was a camera in the courtroom where it came up. That got discussed before the trial, whether the cameras were going to be admitted if it was a high-profile drug trial, for example, and there were informants, that kind of thing. Then that was a trial that sometimes didn't get tested, that didn't get cameras in the courtroom. But especially in California, that was very rare. And again, on individual witnesses, the judge would make certain decisions. So, for example, he might say, we could record the audio, so the camera would turn away and just show the judge, and then you would hear the audio of the person testifying. Or we would agree to black out their face. For the most time, rather than take that risk, we wouldn't show that person at all. But you act like this whole thing's going on in a vacuum. It's not. For example, the Lululemon trial, the 2 Apple employees who testified, they didn't want to be on because they were somewhat embarrassed. They had heard the woman's screams and hadn't done anything. We waited for them to come out of the courtroom and interviewed them then. So people still going to get pictures. The media is still going to show up in a big trial. It's still happening. It's not like no one knows these people are testifying or that there's something going on in the courtroom. And again, I go back to, for 30 years, it's been going on in every in a major state like California with every kind of trial, and we found a way to make it work. And I'm not aware of, I can't remember reading anything about a huge problem where witnesses refused to testify or they couldn't work something out with the courts. I'm not aware of any examples.
See, that's why the media can't be trusted to know the answer to that, though. And that's why I think the Judicial Conference said about trying to get some objective information on that very question. The media wouldn't know that the prosecutor couldn't call a witness because of that. And that's why we need some kind of objective information on that kind of question, I
Didn't the
think.
Judicial Conference do a survey back in 1994 after the last experience and basically came up with a series of findings that said yeah, 90% of the witnesses said they were not intimidated, and 10% said, yeah, they were kind of, nervous about it, and then they interviewed. Are we reinventing the wheel here?
I think that's not totally unfair, but that was really a survey. It wasn't the kind of experiment that we're trying to do now, where we're actually doing the cameras and getting people to explain their reactions and documenting the reactions and so on. That was really just a survey.
So you've done some social scientists are on a contract to do all
That's
of
right.
this?
That's right.
Fred?
But I was just, after 30 years, I mean, there's no, how much?
Well, I thought OJ killed it for 30 years, so apparently OJ didn't, but a lot of us that watched OJ thought it was
Killed it on the
for our
federal
lifetime.
level, not on the state level. The state level, we've been
No, I
seeing
understand.
progressive access.
But I thought it was dead on the federal level. It's not, apparently.
Why does that have to do with cameras in the courtroom? That jury
In
decided
terms of
that.
witness questions. You don't think witnesses in OJ shaded their testimony because of the cameras? I do.
In what way?
Ask
Why
some
would,
of
how would
those.
they change their testimony so they?
Ask some of those police officers that testified on camera. It was a disgrace.
Okay, let's move on to some of the, we've already had, CCE had a fairly substantial conference session on blogging and tweeting and social media and all of that. But it was kind of interesting to me that on the in the West Coast in particular, it's becoming far more routine to allow blogging and tweeting from the courtroom, not just the auxiliary press room. And recently, in U.S. District Court in Houston, in the Allen Stanford case, the federal judge in that case allowed reporters to live tweet from the courtroom. Are we seeing some movement here to allow that in courtrooms in this area? And is that really all that different? How is that different, in your estimation, from allowing cameras?
Well, I think live tweeting, and there are some dangers with that as well, but it's not quite as dangerous from our perspective because there's not the actual witness testifying, won't have quite as chilling an effect. We've had that in some of our cases, and I think if it's done responsibly, it can be educational, but at the same time, you do have to worry, and you have to worry about what's being said. People react to that. We've seen some bloggers or tweeters talk about the attire of the prosecutor, the attire of the jurors, and you want people focused on the right thing and not the wrong thing.
Does that hurt anything if they?
It doesn't hurt anything, but it doesn't hurt anything. But I think it's important to kind of keep the focus of the trial on the right thing, keep everyone in the courtroom focused on the important thing, which is doing justice. I'll give you one example of one of my concerns, which is there's a website out there called WUSA-TV.com that you may have heard about, and oftentimes we deal with individuals who are identified on that website, some of whom may have testified, some of whom may not have testified, and there are threats made against them and their families. I can imagine a situation if there's a camera in the courtroom where you just have video, you can just actually see somebody and see their video testimony years after they testified, and no matter what's said in the media or print or on a Twitter feed, it's not going to be as compelling, not going to be quite as powerful as seeing somebody's image. And because of that, it won't have the same effect, I don't think, on our witnesses and their ability to testify.
Judge Lopez, what percentage of the cases that come up in criminal court, in Superior Court, are these very intense, incredibly violent, drug-related and other homicides? What percentage of the criminal caseload in D.C. are these cases where it's just dangerous to breathe in front of these people?
I couldn't give you an answer to that. I have no idea. Knowing from the culture that we have in the District of Columbia, and I don't know if that can be distinguished from the rest of the country, the smallness of the District of Columbia, the anti-snitching culture that we have here, the fear that people have is just tremendous. I've seen it from the inside of the courtroom. I've seen it from being out in the streets, from knowing about people, family members that have had somebody killed. And I see it, and then everybody knows each other. Everybody's so close to each other. I don't know if that's another factor.
Well, let's talk about people who aren't here, who can't defend themselves a little bit. I think we've evaluated, and heard Judge Lamberth, I think you just said that you think the notion of appellate court judges and cameras watching the U.S. Supreme Court perhaps would be different. As I mentioned, the Supreme Courts or the highest appellate court in 37 states allow camera coverage. In fact, I remember back in Minnesota covering my very first Minnesota Supreme Court argument, I think in 1979. And it was just fairly routine. You show up and there's the camera and that's that, and very seldom do people even want to watch those folks. But it was very, very routine. It struck me today that something very interesting has happened in the last few weeks at the U.S. Supreme Court. And this is just totally anecdotal. But as I mentioned, the Reporters Committee and other media organizations petitioned to get cameras into the healthcare arguments. We were pretty sure we were going to be unsuccessful, but it was important to be on the record advocating for this. It's one of the biggest cases that we're ever going to have in my lifetime.
But you got some movement.
Well, yeah, we got some audio. But there was something else that happened this time that hasn't happened before, and this involves social media. The news organizations that had lots of money to pay for lots of people and had the credibility to go to the Supreme Court press office and get multiple people in that courtroom did this peeling off like a banana thing today. The Wall Street Journal and Dow Jones, between them, had 4 seats in that courtroom, either the courtroom or the overflow room. And they started out, and I first found out about my husband, who doesn't watch this at all, emails me and says they're live blogging from the Supreme Court. And I thought, how's that possible? Well, I did some investigating, and what they did, they had people, and then the first person peeled off and went out and blogged it. Then stayed, and 30 minutes into it, the next person peeled out and went out and blogged it. And there was also somebody in the lawyer room who violated all of the rules, and after about 45 minutes got nailed. But he was tweeting from the lawyer room because he was in there listening to the live feed. Now, the appetite for this argument was incredible because I was watching the blog and I was looking at all the comments. And the Wall Street Journal's webpage was lighting up like a Christmas tree with people watching this whole thing. Do you think we've kind of come to a point where the Supreme Court may have to pay attention to the fact that people are interested in what they're doing? Anybody? Fred?
Yeah, I mean, just on the whole issue of, text messaging out of court, I was part of one of the first in 2005. It was a corruption trial in San Diego. And we had asked the judge, had, of course, banned cell phones in the courtroom, but he didn't ban using your BlackBerry as a text device. And we said, is that okay? And he said, yeah, we didn't bother to bring it up with our competitors. And we beat everybody by 20 minutes. And at the Hughley trial, I mean, what you brought up that's going on at the Supreme Court is the same thing. It's this knucklehead stuff of trying to get 4 people in so that you can run these shifts and have people run out and text and run back in, which seems very disruptive. And whereas if someone was just sitting in the back quietly texting and getting the information out in a clear and accurate way, it would be better. And we had interviews with people lining up for 3 days at the Supreme Court because it's the only way they can participate.
Well, I have to say in our court, we really have successfully dealt with that, even in criminal cases, because we did set up this press center, media center, that has an overflow camera from the courtroom, only can be seen there. But we let between 30 and 60 press people and bloggers sit in that room. It's a live feed from the courtroom, and they can blog live as the trial goes. We did that in the Libby trial. We did that in the Roger Clemens trial. We're going to do that in the new Roger Clemens trial now. And even in criminal cases, we have found no adverse impact. Of course, we don't have any of these witnesses that are being threatened with their lives. But in those cases, we've found that works, and we've have worked out very cooperative deals with the press and with the bloggers for that to be a successful approach for our court. But we're not allowing it from the courtroom. It's from the overflow room.
Kathy, how many times over the last decade and a half have you gone up to the Hill to listen to a hearing in the Senate Judiciary Committee where somebody wants to force the Supreme Court to allow cameras in their courtroom?
Well, I've stopped counting, but sunshine in the courtroom legislation has been introduced in Congress consistently from 1997 until the present day. Beginning around 2007 is my guess, Senator Arlen Specter from Pennsylvania started also introducing legislation that targeted specifically the Supreme Court, and it would force the Supreme Court to open their doors to cameras under certain circumstances and with certain limitations. I think the debate for the past many years has been logistical technology arguments still existing back then in 97 when legislation was initially introduced. Then it shifted to policy arguments. I think Senator Specter's legislation carried with it some baggage that his intent was really punitive because he wanted to keep tabs on the Supreme Court because they were overturning congressional legislation. So the spin associated with his particular piece of legislation wasn't always a positive one. And obviously to date, none of this legislation has passed. As I suggested, I think the debate has largely evolved, and we've kind of arrived at the point now, and this is going to sound strange to say, but I'm almost glad we're talking about separation of powers and a justiciable issue as opposed to some of the policy arguments that have been made over time. That said, I don't think there's a real appetite for somebody to force the issue of separation of powers and to really tee up the question, pass this legislation, and have, Justice Kennedy has not so subtly said, go ahead, pass your legislation and we'll strike it down, to really tee up this separation of powers issue. And I think most of Congress feels that with time, the Supreme Court will, of its own volition, allow cameras in the court.
Anyone have any thoughts on whether or not that is likely to happen?
Well, the Supreme Court has a special way that they do arguments. They have a unique club of repeat litigants and counsel that they like. They use the argument in a unique way of conversing among themselves more than I see panels of a Court of Appeals do. Maybe in an in-bank Court of Appeals, it's more similar to the Supreme Court. A panel of the Court of Appeals, the judges aren't using counsel to talk to each other, but in the Supreme Court, they really are. And I think there's a great worry there that if you open it to cameras, it will change the whole dynamics of the practice they're very comfortable with and that they like, of how arguments are presented and how they utilize arguments. They utilize questions to really influence other justices to their positions. It's a unique place in our country where this is done, and I don't think there's any other court that really does it quite like that. And I think that's part of why they're protective of that function, because they think it's very important to how they go about deciding cases. And in fact, shortly after that argument is over is when they vote, and that's when the cases are in fact decided, so that it's a very critical time in the case. And I know that's part of why they have adhered to this rigid view that they don't want cameras there. I think it's an interesting step that has been taken regarding blogging, and I think that might satisfy the media more than is at first apparent in terms of what's going on there.
I don't think it's speaking as the moderator.
I don't think it satisfies the media. And in fact, I don't think it should satisfy the court, because part of the court's criticism of media coverage and cameras has been that there's not appropriate context. There's not a depth of reporting. And yet they would keep out something that's going to tell the whole story. And part of the technology, yes, we've evolved away from obtrusive cameras, but we've also developed new kinds of platforms. C-SPAN has for years said, we'll do gavel-to-gavel coverage as a way to appease the justices and say, well, the public can see the whole thing. They won't see the snippets on the nightly news. But now we have, C-SPAN could do gavel-to-gavel. Broadcast stations are devoting digital channels to gavel coverage in the states. They're doing it on the web. So that's kind of, eviscerating that argument as well. And I don't see why the Supreme Court would prefer to have the filter of a person blogging in the courtroom present what's going on inside.
I did a survey before I came over here, and I went to some of the major news organization websites. And I think virtually all of them had posted the transcript, posted a link to the audio, posted their own stories, had a link to if they had the bloggers and the tweeters there. I mean, the Wall Street Journal and Dow Jones were able to pull this off because they could afford to have 5 reporters there. I don't think, could you have 5 reporters there?
No, we have 2. And that's, a bigger percentage of my staff than Wall Street Journal's staff.
There's, I think, 117 reporters total.
Yeah, there were 117 reporters total, and the overflow room, I think there were like 13 of them sitting in Kathy Arberg's office. She allowed extras in there.
But and it's so much easier now with streaming that you could just put the trial up and stream whatever trial it was, and if people wanted to listen to the whole thing gavel to gavel, they could. I mean, I know with the Westerfield trial in San Diego, which was a very big murder trial, we blew out all of daytime, and we were carrying huge portions of the trial, and then every year we were doing a half-hour special with 2 lawyers doing analysis of the trial. We did the same thing with Jeffrey Dahmer. Every night following the 10 o'clock news, there was a special half hour that we did with lawyers analyzing what the testimony was that day and what the significance of it was. So I do think it's educational. It's certainly more educational than some guy with an easel sitting around drawing, and we show 3 pictures of that. By the way, at $3.50 a pop, which really is.
There is a question that came up from one of my legal fellows, and I didn't know the answer to this, but I'm betting somebody here might. Judge Lopez, perhaps you, or maybe Ron or Michael. Is the District of Columbia's unique legal situation as kind of a being overseen by Congress, does that make the decision-making on who allows cameras in the courtroom? Are you beholden to whatever the judicial conference decides the camera policy will be, or are you able to decide on your own?
We are able to decide on our own through our board of judges, yes.
Okay. All right. We have probably 15 minutes left, and we promised we would allow the folks in the audience to ask questions. And Pete has a microphone. Is that Alan over there? Yeah. And if you could just tell everybody who you are, because we are recording this.
Alan Morrison, George Washington Law School. My question is a simple one-word question. Radio. Why not radio? Speaking for myself, I would probably almost never go to the court if I could listen to it radio. I would also love to hear them read the opinions instead of having to worry about scurrying around with them, deciding whether I'm going to listen to them or not. I know for many people it feels like it's a compromise, but isn't it a pretty good compromise, and get used to it? We don't have to worry about anybody seeing anybody or identifying anybody. I'm talking about the Supreme Court, of course, not the trials.
Well, that was one of the questions that we had. Were they going to allow it, after contemporaneously, were they going to allow it the same day, or were we going to have to wait for the whole thing until after day 3? Anyone have any thoughts on the audio issue, contemporaneous audio? Fred?
Well, the only thing I would say, listening to the judge's comments, which I thought were interesting about how they interact and how they're worried about it might affect them. I mean, once you're being recorded, does it make a difference? I don't know. I mean, I'm not a Supreme Court judge. I have a hard time, obviously, I believe.
Well, one other argument I've heard them make is if you have cameras, then does Ford Motor Company as a litigant have to have a telegenic lawyer who then speaks to the millions of people who are watching in a way that people who buy Fords are more influenced? Is that more important than arguing to the court? And I know that disturbs more than one justice on the court because I've heard them make that argument. That's why they're worried about it affecting the arguments themselves.
Yeah. I just think
What would Ford do?
I just think that's a misconception in that the best-looking anchor team in town isn't always the number one anchor team in town. I think there's this assumption about TV that everybody has to be beautiful in order to be effective on TV, and I can think of many, many instances to prove that that's not true.
I just want to.
Your anchors thank you for that.
It may be true what you're saying about the news people, but the people on the rate on the commercials are all beautiful.
One thing that does strike me, however, is that hearing their arguments about essentially what they're saying is there's only a certain segment of American society that is worthy of listening to us live, and isn't that kind of unfortunate?
It is. That one I'll concede.
Any other questions out there? I thought I saw another hand. Oh, Laura?
When I was an assistant U.S. attorney, the most powerful moment was the sentencing. Was sentencing. And I wondered if you think that would have a deterrent effect if people could see the sentencing process and the care with which judges mete out their sentence and the effect it has, and hopefully it encourages people to be more law-abiding.
Ron?
I would have less of a concern, but I still think it would be a concern. I was a defense attorney for the last 8 years before I became U.S. attorney, and if I go back into that mode, I would be very nervous about the effect it could have on the judge. Will this judge be seen as soft on crime? How is this judge? Will this judge really have to demonstrate that he is taking this crime seriously and kind of come out with very strong words against my client? And so it's not to say that these issues can't be overcome, but it's just there are all these risks, and for the lawyers, it's weighing those risks versus the benefits. And I know the benefits are often couched as it's educational, but when you look at these media services around these trials, it's drama. It's not necessarily, we do a lot of education on the court process, on people learning about the court system. We spend an awful amount of time going to the community and doing that. It's very different than what you see in trial and the snippets you get. It's entertainment, and all the parties become stars. And I think for a lot of the folks on this side of the table, except at the end, I guess in the middle, the issue is there's a danger there, and we just don't see that it's worth it because our focus is doing the best job either for a client or for the government or for the victims or as a judge, for justice. And so we just. I think that's where you see the reluctance.
But Ron, the Lululemon trial here, you saw everybody. You saw the witnesses, you saw the families before, after, during, you saw all the attorneys come out and speak. It's happening anyway on a big trial. And we're not going to put cameras in. The other interesting thing is the media is not going to be interested in every trial. It's going to be the big trials. It's not going to be every single drug case, and maybe we should be doing more of that run-of-the-mill stuff because those are important cases. But for the most part, it's going to be the bigger trials that are getting tons of coverage anyway, Hughley, Lululemon, those kind of trials. And all those things are happening now. And I don't think in as good a way. I think that they could be more controlled and better. In my experience in Wisconsin and in California, with Dahmer, where we sat down with the judge and we said, Your Honor, what are you worried about? He said, I don't want people running all over the courthouse with cameras. It's not going to happen. Where can we have them? Where can we do our, if the attorneys or anybody wish to speak, where can that be? Where can we not be? And we laid it out, and it was controlled. And I think that's why it was successful, and I think it's a better experience for everyone. And in the cases where you talked about the dangers to witnesses, we don't want to be responsible for a witness being killed. And, for example, in any kind of murder story, if we interviewed someone and then they said they were threatened and please don't put me on TV, in most cases, we're probably not going to put them on television.
That may be you. And when you have the media, there are different levels of responsibility among different media levels. And so, maybe you're that responsible, but others may not be. And once it's out there, it's out there.
Michael, do you have any thoughts on Laura's question?
Well, I think, the thing about sentencing is they are the time, perhaps more so than any other part of a criminal proceeding, where the intimate details of at least a defendant's life and other issues in the case really become paramount. And so that would be very disconcerting to me, is the nature of my client's life, the way, and other people who might speak on his behalf, or even the victim's life and how they've been affected by the crime, would become front and center for the public to, I think, to I don't know what. I mean, that seems to me the issue, and what distinguishes the trial level from the appellate level, that even the cases that Fred has talked about in Maryland, in Virginia, the Hoogley trial, these different trials for which there's been lots of media attention, what is gained by that? I mean, if it's ultimately a little bit of a balancing contest or a cost-benefit analysis, what is ultimately gained from that information, from that exposure? Mostly, people are interested in it because of the drama, because of the unique characters involved, and the intimacies of their lives that are exposed. And this notion that it educates the public, I don't know that it educates the public about the legal system. Frankly, when I go into trials as an experienced criminal defense attorney, that I'm not too familiar with the facts or the circumstances of the case, it's difficult for me to understand what is going on in that case. I had a trial last August that was blogged that I decided to watch because I thought it might give me some insight into the judicial process and what the jurors are thinking. And what shocked me more than anything else was that this person seemed to be watching a totally different trial than I was trying.
But isn't that the point?
Right.
You're talking about media coverage generally. If you have the eye in the courtroom that's presenting what is happening, not through a filter of the blogger. I mean, that to me is the most compelling argument in favor of cameras, that you stop the Lord of the Flies scene, as Fred said, and rely on that kind of coverage to educate the public.
If you have confidence in the ability of the public to watch a legal proceeding, which often involves complicated arguments of law, to comprehend it, understand it, and draw the inferences that should be drawn from it.
But Michael, respectfully, it's not your process, it's our process. It belongs to the public, we're paying for it. And everyone has a right to see it, and they have a right to misinterpret it and be stupid. And, I've been dealing with it for a long time. So people will see what they want to see. We can't control that, but they certainly have a right to see it.
And that's fine.
Walk into the courtroom and sit down and see it.
That's fine. I don't disagree, and certainly I'm not, an anti the First Amendment in terms of public information. I agree with that. But if that's the argument that why it's compelling, why we ought to do it, it's sort of an empirical question of it being effective in doing what it's supposed to be doing, namely educating people, and contrasting that with the costs associated with it. The cost to witnesses, the cost to defendants who, frankly, from what I understand, there is sort of this perception in the media that they're already guilty, and that's why they are the ones whose faces are always revealed on the screen, even though jurors and witnesses are not shown or are dotted out because of this sense that they're on trial, therefore they're guilty. We're going to show their face. We're going to reveal the details about their life. We're not going to give them the right to say, I don't want this to be covered necessarily. And with respect to the other cases where there's going to be coverage and you can talk to the witnesses or other individuals when they come out of the courtroom, they have the right to say no to that. Whereas if there's a courtroom, it's a trial, well, that right is lost.
Well,
Okay,
right
we're going to move on to another question from Chuck Tobin.
Hi, I'm Chuck Tobin. I'm a media lawyer with Holland and Knight here in the district. I just want to comment. I think it's fascinating that we've come down to an argument, if I'm understanding it, from the government that judges are too weak to not remain impartial when cameras are on them, and from the defense counsel. defense counsel.
That is not what I said.
Sorry, Ron, but that's my interpretation. And from defense counsel that the public is too stupid to understand what they're seeing when they're watching a trial. But that wasn't my question. That's just my observation from the audience. Having argued these cases and having lost, I was the lawyer who was unsuccessful in the Hughley trial, getting Judge Hogshire to admit cameras in. It seems to me that when you get up and you make the argument and you face all of these issues and you make your bargains with the judge that Fred has talked about, you're trying to assuage each issue one by one. We won't show witnesses. We will leave the courtroom. We will shut off the cameras. We will let the judiciary staff control our cameras so that they can dictate the shots one by one. It just comes down to a simple argument from the lawyers in the case and the judges that adopt them that it's just too much work. It's the middle of the run-up to trial. I've got these witnesses to manage. I've got so many seats in my courtroom to give out. I don't want all this technology and all this swirling about going on. And I don't want to try and manage the risk that I understand the lawyers are telling me that we can manage in the process. So my question really is, does it come down to the fact that it's just too hard, it's just too much work to try and piece through this process?
I think I said earlier, I think it does add a potential burden. There's an efficiency standpoint if there have to be a lot of motions filed. But again, the nature of our practice in Superior Court, so much of it revolves around violent crime that my most significant concern is witness intimidation and the effect that this could have on their ability to testify.
But you have the tools at your disposal. You have motions you can bring. Even in Florida, the most open jurisdiction when it comes to cameras, has in the rules of judicial administration criterion the judge can follow to exclude, to even close the courtroom if it becomes necessary. So why not use those tools rather than just simply closing cameras out completely?
I mean, but the point was, it's very difficult when you go to a witness and you're trying to get them to testify. They don't want to testify. If they realize that they're going to be on TV during that testimony, and it's just going to make it that much harder, even if we're going to be successfully able to prevent them or shield them from testifying in that trial. Just the general knowledge that is occurring, that people are on TV. When they go down to Superior Court, they're going to be on TV. That is a risk and a concern to us that makes the job that much harder, and it's already pretty difficult.
What about the spy in the audience who's watching and running outside to tell, to block?
No, I mean, that can happen, but again, it's not the same. It's not as chilling, it's not as compelling as seeing somebody's face. And you have that running over and over again. The blogger, you got to remember, somebody has to watch that blogger. It's still being relayed, what's being said. And so certainly there are concerns about that, and we do have concerns. But I don't think that they present the same dangers as a television.
Have you had that conversation with a witness? My last question. Are you speaking hypothetically, or have you had those conversations?
I was a homicide prosecutor before I was a defense attorney, so I dealt with these issues in D.C. very often.
Thanks.
It's just like, hi, this is Joan Davenport. I wonder if there is a chilling effect for the judges who will be on video camera from a security point of view. Does that bother the judges, having people see them there, and given in this day and age all of the violence that's been perpetrated against the judges for one reason or another? That's never an issue.
I don't hear that articulated as a great concern. I suppose it could be, but there's so many people that would like to murder me that I don't, what's one more group, I mean, I've got so many, no, I'm even on our court website, so but I don't think that's a great
I think
issue.
that, I will say this, I think that is a good question, because the rate of threats against prosecutors, my prosecutors, is going up a lot. It's happened a lot more frequently than it used to. The threats against judges, which we investigate, have gone up a lot. And when you have somebody's face there, you just never know. Again, I don't think standing alone that would prevent anything. But because our guys are pretty fearless. But it is a concern. It's something I worry about, even if they don't.
There was a question over here. Microphone, there's right behind you.
I just had a quick comment in response to your question.
Can you identify who you are for the?
Yeah, I'm sorry. I'm Vince Cohen. I'm the Deputy U.S. Attorney for D.C. I did a number of sex offense and domestic violence cases when I was on the line, and you spend months with the victim witness advocates trying to get a rape victim to come forward, to come forward and even talk about what happened to them. So you can imagine what time and what fear they spend getting themselves ready to do something as testify at a sentencing about what happened to them. They have to repeat it over and over again. That is a situation in which if there was a camera in the courtroom, not even a material witness warrant would get these folks to come forward. So that's a kind of...
Fred, can I ask you this question? I know, and I'm a little bit familiar with this because I used to work as a trial lawyer in Minnesota. And as a reporter, we'd go to Wisconsin now and then. It was like nirvana.
It's a great state with a great football team. Go Pack.
If you were to go over there, I mean, number one, are you guys? It's not like you just go in there and say, "I'm going to cover this stuff with a camera today," right? You don't.
No, there's a coordinator who has to contact the judge. The judge talks to the attorneys involved. If they raise any objections, then a decision's made. And again, we never show sexual assault victims, ever. Even in normal, forget trials, I mean, in any kind of story about a sexual assault victim, we never show them unless a woman chooses to come forward and she wants to speak about her experience. And only in that case. I mean, that's standard policy.
Does California work the same way? Do you just decide one morning you're going to go up and take your camera to the courtroom?
No, you have to put in a formal request with the judge through the designated media coordinator for that area. So he or she notifies the judge that you want to have a camera in the courtroom, and then it goes from there. And then the judge tells you yes or no. If he or she says no, then they give you a reason why, concern safety of the witnesses, or if it's a sexual assault trial or whatever. And then we can choose to appeal. If we choose to appeal, notify the judge we want to appeal it. But it was a pretty smooth process, and in both California and Wisconsin, most of the time it was fine. Sometimes there were some very specific details they wanted to work out about specific witnesses, if they were minors, for example, that kind of thing, and we talked those things through. But it was a very smooth process.
And I think that underscores this isn't a one-size-fits-all proposition, that cameras in or cameras out. I mean, that's my experience with members across the country, is that there is always ongoing dialogue between the media and the judges and the courts and their representatives about what is going to work for any given proceeding.
I saw that, yes. Here.
Just a bit of a two-part question here, and Kathleen.
Could you identify yourself?
I'm Carl Racine. I'm Brian Schwab and everybody else at Venable's partner here, and definitely welcome. Two-part question. One is real brief. Who watches this stuff?
Lawyers.
Seriously. Who watches it?
Lawyers.
Yeah. Okay.
I think it depends on what it is. Certainly, the high-profile criminal trials, admittedly, those are going to get the biggest audience.
Okay. And you cover those, I suspect, because your ratings go up?
I'm sure television stations do.
And so
sometimes they do. I mean, something like Lululemon, I think that would be.
And there's advertising involved as well?
Mm-hmm.
But don't forget,
cynical, but it seems
ratings go up because of public interest in the content of the programming. When I was talking about that John Goodman case in West Palm Beach, where they did gavel to gavel on their website, page views skyrocketed. At the same time, they actually provided a chat room with legal analysts to answer viewers' questions as the proceeding was ongoing. So if something was excluded from evidence, somebody could type in and get an answer from a lawyer. And it was a rousing success. And yes, capitalism Scripps, in this case, I'm sure made money off this.
So what I'm hearing,
also,
Kathleen,
what
is-
an educational opportunity.
Okay, Kathleen, so what I'm hearing is that the real argument is we need to educate lawyers about our legal system, right? That's why lawyers predominantly are watching this stuff, and that there is a strong
I disagree with
commercial-
lawyers that are predominantly watching.
All right, I was just listening to Fred.
Kidding.
Mm-hmm.
Okay. All right, well, I'll leave it at that.
It's about an open society. If you can walk into the courtroom and watch it and have some guy with a bunch of paints sitting there drawing it, why can't we just, how obtrusive is that? I mean, I don't even notice it. The gentleman in the back, it doesn't make any noise. It's not a problem. And again, we've had 30 years of practice, and no one can cite for me other than the O.J. Simpson trial, which is L.A., which, having worked in Southern California for 12 years, is another planet on every level for anything you could possibly want to do there, trials or anything else. Not a lot of problems. I mean...
And we've focused on, public education, but what about government accountability?
The judges sleep less on the bench.
I mean, I've been on many panels with judges who say they mind their P's and Q's. I'm told we have time for one more question.
Hi, Sharon Goody, former Assistant Corporation Counsel, which is now known as Assistant Attorney General. One thing that the media doesn't always hear about is when you get something wrong. And I know that I had a high-profile trial in some homicide about 10 years ago where I would read about my case in the Post day after day and see it on TV. There were no cameras in the courtroom, the Superior Court. The stuff was just wrong. I'm sure it wasn't Mr. D'Ambrosio and it wasn't Ms. Dalglish who were doing the reporting. But they were saying the judge ruled A and the judge had ruled B, or some of the information they were putting up was so wildly out of context that it was very distorted. So when the thing went to trial 2 years later, I wasn't there for the jury part, I was there for the kid part. I was kind of wondering how difficult a challenge that was for that judge with the juror pool. So the question I have, I'm going to mimic Professor Morrison, editing. I get the streaming gavel to gavel, but so much of what we see on the news, on the half-hour news, is a 1 minute or less snippet, and how can the media be more responsible for what's getting snipped?
Yeah, I mean, I think it's an educational process, and I think we learn as we go, and we try, for example, the Lululemon trial, we try to book lawyers to help us understand what we're seeing, because we're not lawyers, although some newsrooms do have people with law degrees who do cover these trials. Gary Nuremberg in our news department has a law degree. But I think it's made easier by the cameras in the courtroom. I mean, the case you're talking about didn't have anything to do with cameras, just bad journalism. We did a bad job, and we don't do a great job. And it is really hard to condense for an expert like you, who really understands what's going on, into 2 minutes or a newspaper article. It is really difficult because there's so much backstory you'd have to fill in. And you see this with the Supreme Court yesterday, this whole thing about having to explain the whole tax. You can't adjudicate it before the tax is actually levied, and it's hard. There's a lot of information to give out, but we do the best we can.
But if I can just follow, here's the problem. With me, it was print people. Only print people were allowed in the courtroom. There were journalists outside the courthouse every day with the cameras, and they were bigger back then. But once it's on TV, it's so much more powerful when it's visual. If you've made that mistake, you can't take it back. So is there some way that journalists can help us feel more comfortable as litigators and as judges that you're going to be more careful or get more JDs in the courtroom or something to get it right? And I don't mean like Nancy Grace, who scares me every day, but people we can rely on so that snippets are accurate.
Again, I mean, we strive to be accurate every day, and I had instances in San Diego and Wisconsin where I've been called by judges or lawyers saying what you guys said wasn't right, and in every case, you strive to correct it. More than happy to put the prosecutor on or the defense lawyer on and have him or her explain why we got it wrong or why their point of view wasn't adequately represented. And I think that's all you can do is be open, But you have to tell us. If you think we're doing a bad job, someone has to call and tell us, because clearly we didn't purposely put it on to distort it. We think we're doing a good job. So we just need that level of communication. And I realize sometimes in the course of a trial, maybe you can't do that, but you certainly have a colleague call.
All right, well, that's our program for tonight, folks. Thank you very much for coming, and thank you to our panelists. From June and Pete about the next upcoming panel, I'm sure very soon. Thank you.
Nice meeting you, Ron.